Well, hello, everybody. This is Dave Burkus for another piece of advice from Burkonomics. And this one will be a little controversial. Can your lawyer destroy a good business deal? Let's talk about lawyers. Over the years in business and as a member of over 40 boards, I've received good advice from corporate attorneys and occasionally bad advice as well. There's a line that should be drawn in a relationship between a corporate attorney and the CEO or the board. Attorneys are paid to protect the corporation, not to give business advice. Now, some are experienced enough to provide that good business advice, and we need to know when. But the law degree they earn does not assure that even though most CEOs respect the advice they receive from their attorney highly enough not to doubt the conclusions or the experience behind the conclusions offered. But the attorneys are paid to protect, and often they'll give a litany of warnings about what could go wrong when accepting a contract clause that they might have been trained to challenge. There comes a time when the CEO has to decide what might be more important, good advice from the attorney or a chance to accept the terms within a contract that may cause risk, but controllable risk, or risk that is sometimes so remote as to be worth the acceptance of all business represented by the contract at hand. Here comes another one of my stories, of course. I was chairman of a company that had been offered an investment by a Fortune 500 company offering to make a strategic investment in our business. And it would be capable of driving new demand to the large company through a series of new web services, creating a greater need for the large company's products. Win-win. The business terms had been agreed to between the business development officer of the investing company and our board, as both companies turned the details over to their respective attorneys for documentation. The attorney for the investor was a member of a large, respected firm in Silicon Valley, and certainly was full of himself, that's my opinion, as sole legal protector of the rights of his very significant investor. As drafts of the otherwise standard investment agreement passed from him to our attorney and to our management and to me, we immediately spotted a significant number of terms we not only had not agreed to, but were contrary to the spirit of the investment. The attorney held to the defending of every challenge, stating that, quote, these terms are standard for our client and cannot be changed, unquote. We appealed to the business development executive, who deferred to the attorney, restating that the terms were unchangeable as far as the big company was concerned. Well, after conferring between our attorney and our board, we walked away from what would have been a fine strategic relationship, killed by an attorney who probably understood the client requirements, but was unwilling to offer a flexible solution to problem areas. That attorney had made what we consider to be business development decisions on behalf of his client. By the way, we immediately found a willing replacement that an attorney not quite so full of himself and quickly concluded a similar deal to the acceptance of all. And to this day, I caution my CEOs not to deal with a Fortune 500 firm because of the experience we had with that attorney. You know, you never know how much far-reaching an action can be, given the speed and extent of communication between CEOs today. Well, attorney friends, go at it. In the comments column, do what you can. I'd like to hear your opinion of this insight. And that is an insight from Burkonomics. We'll see you next time.